We have breaking news on a highly anticipated decision from the Supreme Court.
The Supreme Court has decided.
And today, the Supreme Court
is now setting.
You couldn't guess, it's been a busy last couple of weeks for the Supreme Court. You had rulings on accommodating LGBT weddings, vis-a-vis flowers and cake shops. Partisan gerrymandering was up there. Public sector unions. The third iteration of President Trump's travel ban was upheld. And on top of all of that, Justice Kennedy freaking retired. If it sounds like a lot, it's because it is. This has definitely been a very busy term. Normally I'd like to just, dive in 100% into a single topic, but since people are already forming opinions that are more contoured by the clickbaity titles of the so-called hot takes than, the content of the rulings themselves, I felt like that we should talk about what's happened, or at least talk about as much as what's happened as we can. But you know what that means? A 1 hour long video on the minutia of constitutional law. Yay! I mean, obviously not. Y'all already saw the length of the video when you clicked on it, and, thanks for that, by the way. We are going to be doing something a little bit different. Instead of addressing a single topic for just this video, we're going to address these four in a kind of poli-sci lightning round. We're going to put 2 minutes up on the clock for each topic, and I'm going to try to give as quick a summary as I can without going over and without sacrificing too much accuracy. Starting with Masterpiece Cakeshop and Arlene Flowers. I'm going to be bringing out the kind of rapid-fire talking that y'all have been trying to get me to stop doing so much of, but it's necessary to keep within the time constraints, so, just be warned. Masterpiece Cakeshop v. Colorado Civil Rights Commission and Arlene Flowers Inc. v. Washington both focus on the question of whether or not vendors providing wedding services to the public have the right to deny service to LGBT weddings due to sincerely held religious beliefs against the institution of gay marriage. In the case of Masterpiece, owner and cake decorator Jack Phillips refused to create a cake for a gay couple's wedding. He indicated that he would provide a cake for other events, such as birthdays, but his religious convictions as a devout Christian prohibited him from using his talents to further a ceremony that went against those convictions. In court, Phillips argued that being compelled to make the cake would be violating his First Amendment rights to both free speech and free exercise of religion, as forcing him to use his artistic abilities constituted compelled speech in a way that went against his faith. The Supreme Court ruled in favor of Phillips, but not in the way that many people are taking it. The court ruled in Phillips' favor not because it directly upheld the rights of vendors to deny service to LGBT couples, but because they felt that the Colorado Civil Rights Commission acted improperly in dismissing Phillips' religious objections as quickly and as vehemently as they did. Transcripts showed the members of the commission comparing Phillips' arguments to those used to uphold slavery and the Holocaust. It appeared totally impossible to them that one could have an earnest disagreement with the institution of gay marriage on the basis of sincerely held moral beliefs without it having some sort of sinister element. Because of the First Amendment, objections based upon sincere religious convictions are guaranteed a certain amount of recognition and respectful consideration. They may be ultimately ruled as being more or less important than another right, but that respectful consideration must happen first, and the courts felt that Phillips never got a fair shake. The Arlene Flowers Inc. case was similar to that of Masterpiece, except it was a florist instead of a baker. The Supreme Court remanded that case to the lower courts in light of Masterpiece in order to ensure that the defendant there, Baron L. Stutzman, was afforded that kind of recognition and respect. But the court did not actually decide if it was a right to deny LGBT people due to conscientious beliefs, just as the Colorado Civil Rights Commission dismissed Phillips' objections without proper consideration. Up next, partisan gerrymandering. As many of you probably know, thanks to CGP Gray's excellent introduction to the topic, gerrymandering is when electoral districts' boundaries are drawn in order to confer some sort of advantage. Racial gerrymandering has already been deemed unconstitutional in most cases, except in those instances where the districts are created to improve the representation of racial minorities. That's a whole other can of worms that we'll get to in a different video. The form of gerrymandering that made its way to the court isn't racial, it's partisan. Well, actually, there was a racial gerrymandering case out of Texas, but that's not what we're talking about here. Partisan gerrymandering goes by the same logic as racial gerrymanders, except instead of packing racial groups into as few districts as possible, or cracking them up with several to dilute their total voting power, it's done with people based upon their political affiliation. The Supreme Court had the opportunity to determine whether partisan gerrymandering was unconstitutional. They had cases of Republican gerrymanders in Wisconsin and North Carolina, and Democratic gerrymanders in Maryland, and the courts opined not. Not that the maps were not unconstitutional, or not that they weren't partisan gerrymanders, but that they were not going to take the case, instead opting to send it back to the lower courts. The issue is that in order for a lawsuit to be recognized as worth hearing, those pursuing it must demonstrate what is called standing, and in the US there are 3 requirements for that. The plaintiff must have summoned some sort of injury, that injury must have been caused by the actions of the defendant, and that the court decision must be able to, at least in some way, redress that initial injury. The majority decision, or since it was a 9-0 ruling, more like the unanimously held decision, was that the parties in this case did not demonstrate standing. Specifically, the courts held that the defendants did not demonstrate that they were personally negatively impacted by gerrymandering, but that their preferred political parties were. One of the plaintiffs actually admitted that he didn't even live in one of the districts that were gerrymandered against his political beliefs. So the justices punted, telling the plaintiffs to return to the lower courts so that they can explicitly demonstrate that they have standing to bring the case before the Supreme Court. And I'm personally a bit miffed by this, since part of the opinion refuted some of the mathematical tests used by social scientists to identify partisan gerrymanders for, reasons that I don't totally buy, but maybe it's, I don't know, it could just be me. The Trump travel ban. Supreme Court recently ruled on a partisan 5-4 split that President Trump's travel ban of individuals originating from 8 countries, Chad, Iran, North Korea, Somalia, Syria, Venezuela, and Yemen, was actually constitutional. This was actually the third version of what detractors have identified as the president's, quote, Muslim ban. The other two were revised in face of other legal challenges. It's called the Muslim ban due to the fact that all but North Korea and Venezuela are predominantly Muslim nations, and that President Trump and others have explicitly stated that he would institute a travel ban on Muslims. That's not fake news. Here he is as he first announces the idea as a presidential candidate back in 2015.
Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on.
The courts ruled, however, that this third version of the travel ban, using the president's own words here, was not unconstitutional. One of the arguments garnering the most popular attention was that the president's explicit anti-Muslim animus represented a violation of the First Amendment. However, the majority decision holds that the final policy is, on its face, neutral, and that the selection of these nations were made on grounds that were not religiously oriented. They also point to the fact that Iraq and Sudan were removed from the original list as evidence that it was not a ban on all Muslims in point of fact. Interestingly, though, Roberts insists that the ruling is only really limited to whether or not the president, by virtue of his office, has the authority to make the move, not on the propriety of the president's words or the wisdoms of his actions. One way of interpreting the ruling is as follows. If any other president had issued this ban without making the sort of incendiary tweets and comments that President Trump made, there'd be nothing within it that makes it appear discriminatory or suggest that it exceeds the broad executive powers regarding immigration. Basically, the court tried to divorce the proclamation from the person who made it. It's a move that's inspiring a lot of debate, as many are wondering if the list would have even been made if it wasn't driven by some sort of animus against Muslims. And, as a dissenting opinion points out, even trying to apply the proclamation on its face still demonstrates that several thousand people were denied despite meeting all the criteria for individual waivers. Their denial came for no discernible reason apart from the fact that they came from a Muslim-majority nation. On the one hand, the ruling reaffirms the president's powers ascribed to him by Congress and the Constitution. On the other, it brings up the disquieting question of what such power can do when it is wielded by someone who has explicitly acted based upon prejudicial intent. Last up, Justice Kennedy's retirement. Justice Anthony Kennedy announced his retirement from the Supreme Court effective July 31st of this year. He was appointed by President Reagan in 1987 and served for over 40 years. His rulings include Citizens United as well as Obergefell, the ruling that legalized gay marriage across the United States. This is leading him to have the sort of reputation that's being bestowed upon him, that of a swing voter, of an ideological moderate. With the announcement of his retirement comes exuberance amongst Republicans and disappointment among Democrats. The former are excited at the idea of a reliably conservative court for the next few decades, while the latter expresses consternation at the exact same prospect. But these hopes and fears raise the question as to whether or not the court is already conservative, and arguments can be convincingly levied that, yeah, it already is. This question as to whether or not Kennedy's reputation as a moderate is really earned. Was he the median ideological voter? Sure. Was he occasionally a critical swing vote? Absolutely. But those two things do not necessarily make one moderate. Research done on the relative ideology of Supreme Court justices show that Kennedy is really not as liberal as many point him out to be. He's actually been a rather consistent voice for the more conservative wing of the court on most issues. It's much more accurate to say that he's the most liberal of the conservative justices, other than to say that he is a liberal justice. So does this mean that a Trump appointment isn't going to sway the ideological makeup of the court? Hardly. It's just going to do so in a much more subtle way. The court is in the business of interpreting the Constitution and establishing legal precedent. How things are decided, the specific standards invoked, and the often meticulous wording used are arguably much more important than whether or not they rule in favor of the liberal or conservative side. By virtue of being the median voter, Kennedy had a lot of sway over the content of majority rulings, and his version of conservatism was much more akin to that of Gerald Ford than George W. Bush, let alone Donald Trump. But his absence, coupled with the prioritization of justices with conservative credentials determined by an explicitly activist organization, basically guarantees that any Trump appointment is going to shift the median to Chief Justice Roberts. This will mean that rulings are going to be made in a much more conservative light from here on out. What does that mean for important issues like gerrymandering, abortion, and LGBT rights? Well, we're just going to have to wait and see. But if y'all be guaranteed that whatever outcome is determined in these cases, it's going to originate from much more conservatively oriented jurisprudence. Is that all of them? Whew! Alright, I can basically let go of that breath that I've just been holding the entire time. I'm curious to see what you guys think about any one of the issues that we talked about, or any of the other cases that the court has dealt with over the last couple of weeks, because, again, there's just a lot. There was a lot. We couldn't possibly take care of all of them. Looking forward to seeing all you guys' thoughts on those, as well as suggesting future topics down in the comment section below. Look forward to reading all of them, mentioning a few of them in the next office hour. Sources for everything else will always be down in the doobly-doo, as well as links to Facebook, Twitter, and the blog. Look forward to seeing you guys out there as well. If you enjoyed this video, hope you consider giving it a thumbs up. If you want to support the channel, you can do so by commenting down below, by sharing this video, and by subscribing to the channel to stay in the loop for more awesome social science content that's uploaded. If you want to be guaranteed to be in the loop when I upload a new video, be sure to click the bell icon as well. As always, thank you guys so much for watching. I'll see you next time.